Hi, Josh.
Hi, Amanda. What are we talking about today?
Thought we would talk about a merger or an acquisition. Let's assume that a potential client comes to you and their company has recently been acquired or merged with another company. And they've found that the job that they've been doing for a number of years, they're not really doing anymore. And they don't quite know where their place is in this new and maybe improved, maybe not company. And they ask you, Josh, has their employment been constructively discharged as a result of their position just not being what it was before?
The answer is maybe, Amanda. It depends on what the reason for the constructive discharge is and whether you have contractual protections. So a constructive discharge is a termination without calling it a termination. We've done other videos about that. You could check those out or find more information online. But a constructive discharge is generally illegal only if it is motivated by a protected characteristic or protected conduct. Let's assume that doesn't exist here. What we have left are the contractual protections that an employee might enjoy when their employer is acquired. So we often see in the lead up to an acquisition that the company that is going to be acquired will put in place contractual protections for sometimes all of its employees, sometimes just its senior executives, and it usually takes the form of what is effectively a good reason protection. A good reason protection says you can resign your job with severance if certain conditions have occurred. And one of those conditions is usually that there has been a material diminution in your duties or responsibilities. And if your job has been effectively taken away from you, even if you continue to have nominally the same job, then you have experienced a material diminution in your duties and responsibilities. So in order to figure out whether you have any protection there, whether you can obtain any compensation for what you've been through, you really need to look at the documents in your case. And you probably want to do that with a lawyer because those can be complicated. These are going to be equity agreements or option agreements. They could be in the severance plan, and in the severance plan, they could be in the merger agreement. There could be lots of other complex corporate documents that contain these protections for you. So if your company has been acquired and you feel like you're being squeezed out of your job or not allowed to do your job the same way you used to, that's a time to call a lawyer and have a conversation about what protections exist for you.
Josh, what about a change in control agreement or clause that may be contained in another legal document that an employee signed years or not months earlier?
A change in control clause, Amanda, is typically included in an agreement that grants to an employee either stock in their company or options to purchase stock in their company or another kind of quasi-equity relationship, such as the right to receive money in the event of a certain event occurring in the future. Typically, we see equity and options and sometimes phantom stock vesting over time. That means the longer you stay with the company or the company reaches certain other benchmarks, that is the time period in which you earn the stock. You now own the stock, not when it's granted to you, but over the course of time or over the course of performing in a certain way. Typically, those agreements will contain a change in control clause that says if your company is purchased in whole or in large part, then all of your stock or options or other interest automatically vests and you have a right to it at the moment of a change in control. Likewise, you could have a good reason clause in your employment agreement. This would typically be an individually negotiated employment agreement that says that a change in control will implicate a good reason clause that would allow you to walk away from your job with a severance that you would otherwise only receive if you had been terminated without cause. So if you're dealing with a change in control, if you're dealing with believing you've been constructively discharged in the aftermath of a merger, those are times to speak with an employment lawyer, review the documents very carefully, and make sure that you're doing exactly what the documents require of you in order to realize the benefits that you can receive as a result of that corporate action.
And Josh, what about the employee that does not have this type of contractual protection? Maybe their employer has been acquired or merged with another company. And what it seems to be happening is that the new employer is letting go of all the prior employees, the old guard, if you will. Does that employee have any protection?
Typically not, Amanda. It's not a protected classification to have worked for the target company as opposed to the acquiring company. If you notice a pattern in those terminations, not just that these are the folks who are with the old company, but they're the folks who are older, or they're the folks who are a particular race, or they're folks with disabilities, that's something to talk with an employment lawyer about. But if the acquiring company is just letting go of the folks who are with the target, that's something we often see. And unfortunately, there's typically nothing that the law can help you do about that.
Critically important information, Josh, and we're seeing this come up more and more. If your company is being acquired, make sure you gather up any contracts, whether they are recent or ones that you may have signed in the beginning of your employment in preparation to talking to an employment lawyer, and take a look at the facts surrounding whether you're being let go or there's a change in your employment relationship as a result of that merger or acquisition. For more information, see our website. And thank you as always for watching. Take care.